saying the Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this Honorable Court. Be seated.
Good morning. Before we start today, I'd like to introduce a judge this is the first time he's sat with us here in East Tennessee. He's on the middle section in Nashville, and it's Judge Jeffrey Usman. We're happy to have him here. Call the first case, please.
JTM Enterprises versus Oddello Industries, LLC.
Hear from the appellant.
Yes, Your Honor. May it please the court, my name is Catherine Kurzmarzik and I represent the appellant, Oddello Industries, LLC. I'd like to reserve 4 minutes for rebuttal, please.
That'll be fine.
Unless Your Honors prefer a brief recitation of the facts, I will get straight into the argument. Before this court today are 3 issues: default judgment, whether JTM is equitably estopped from asserting its breach of contract claim, and whether JTM waived Oddello's rent. Specifically, 2 subparts to that: whether Gene Jolly, the managing partner of JTM, had the authority to waive the rent, and what the legal effect of 2 landlord waivers would be. First, Your Honor, in its cross appeal, JTM argued that the trial court erroneously set aside JTM's default judgment against Oddello. I'll address this issue now unless the court prefers me to wait until JTM presents its argument, given that this is a cross appeal. The record supports the trial court's decision to set aside the default for 2 reasons. First, Oddello does not appear to have had notice of the hearing. And second, Oddello established that the 3 requisite factors necessary to set aside a default judgment. So first, to address the notice issue, JTM filed its motion for default on February 6th of 2020. It appears that the court heard this issue 7 days later on February 6th. There is no notice of hearing in the record, so it's unclear whether JTM attempted to provide notice at all. But even if they had, the February 13th hearing could not have been timely. Under Rule 55.01, a party must be served with written notice at least 5 days prior to the hearing. In the certificate of service, JTM certified that it mailed the motion, which then invokes Rule 6.05, providing that 3 days be added to the service period if served by mail.
Counsel, was the notice issue raised before the trial court?
Your Honor, no, it was not. We raise it here today because JTM has also raised certain issues for the first time on appeal. So to the extent that this court is inclined to consider those issues, we're raising this. If your honors are not inclined to consider those issues, then I'm happy to move on to my next point. The other point, which is that Oddello has established that it's entitled to the default judgment being set aside because it did not act willfully, had a meritorious defense, and there would be no prejudice to JTM. Oddello explained to the court, the trial court, that Gene Jolly had told Talia Otto, who's the managing member of Oddello, not to worry about the default and that he would take care of it. Ms. Otto then testified at the hearing on April 28th that she had spoken with Mr. Jolly, and he said, quote, "I'm taking care of it." And Ms. Otto,
what does that mean?
Well, Your Honor,
I'm taking care of it.
Your Honor, this case is a case that every issue turns on Ms. Otto's reliance on Mr. Jolly. So they have a long history together, these 2 people. The record reflects that they spoke 2 to 3 times a day, that Mr. Jolly was very good to Ms. Otto, that he had told her to stay in the lease. She relied on that. So she had a history of relying on him. So taking care of it means that, Ms. Otto took that to mean that he wasn't going to default them. But by relying on that representation, Oddello did not act willfully. JTM cannot and should not be able to capitalize on the misrepresentation of its managing partner to keep Oddello from defending itself in this lawsuit. And there is a meritorious defense in this as well, namely that the rent had been forgiven by Mr. Jolly in what I said was another misrepresentation by Mr. Jolly to Ms. Otto.
Counsel, is there any factual finding from the trial court that the rent was forgiven in this case? The trial court instead seemed to travel along the apparent authority or the authority rationale rather than finding forgiveness. Is there any factual finding of forgiveness in?
Your Honor, there is a factual finding in this record. The trial court made a finding of fact that Ms. Otto and Mr. Jolly orally modified the lease.
But counsel, a factual finding there's an oral modification could be a reduction or a delay. It's not necessarily that it's forgiven, right?
That's right, Your Honor. I mean, this is certainly not the best example of compliance with a rule of making a factual finding. But it is Oddello's position that the trial court did make that factual finding, which was an oral modification of the lease. And all of Oddello's arguments in this appeal are predicated on that single factual finding. It doesn't require the appellate court to search the records. All the remaining issues are legal issues. So that is the single factual finding that matters here. And notably at the trial, Ms. Otto was the only witness with personal knowledge of her interaction with Gene Jolly. This is critical. She testified that the parties had orally modified the lease and that the oral modification to which the parties agreed was that JTM would waive or forgive Oddello's rent. Randall Jolly.
If we find that you're right on the authority issue in this case, doesn't this case need to be remanded back to the trial court for a factual determination here? And it's not clear whether the trial judge is saying forgiven. It's not clear whether the trial judge is saying reduction, delayed. If you're right on authority, doesn't this case have to go back to the trial court to make that factual determination?
Your Honor, it is Oddello's position that it does not, because the only factual finding that could be made is that the parties orally modified the lease for a rent waiver. The other two witnesses who testified, Randall Jolly is Gene Jolly's son. He's not a partner at JTM, and he provided no testimony whatsoever on this rent waiver issue. The other partner in JTM testified, Harold Nichols. His testimony was speculative, what Gene Jolly would have or could have done, not on that he had no personal knowledge. So the only finding the trial court could have made and what it intended is that it was a rent waiver, which is why the trial court then said, well, Gene Jolly just didn't have the authority to do that, which then turns this into a legal issue, not a factual finding issue.
All right, so the trial court's statement that Ms. Jolly didn't have the authority is a question of law.
Yes, Your Honor, it is a question of law. It goes to the revised Uniform Partnership Act, which would beg three questions of the trial court to consider. Was the act of Mr. Jolly in the ordinary course of business? Did Mr. Jolly have the authority to act? And did Ms. Otto have knowledge or receive notification that Mr. Jolly lacked authority? The latter two issues don't appear to be at issue here. JTM isn't making, or doesn't seem to be disputing that Gene Jolly had the authority to act and doesn't assert that Ms. Otto should have been aware of that in the event that he didn't. So the issue actually turns today on whether or not Gene Jolly's forgiveness of the rent was an act within the ordinary course of business. And again, the undisputed material facts, or the undisputed facts here is that he did. The only evidence in the record of the business that JTM conducted is that they owned the property and they leased the property to Oddello. So that means they're in the leasing business. Their purpose was to lease the properties, a property, specifically this property, to Oddello. So decisions concerning rent, execution of leases, waiver and forgiveness of that rent in an effort to keep a tenant in a lease would be within the ordinary course of business. And Tennessee case law supports that. There is a case, Bull v. Lyle, which gives this court an example of the type of business that would fall outside of the ordinary realm. In that case, a crate manufacturing company, a partner in a crate manufacturing company, went out and purchased lumber or land to supply lumber needs for his crate. Ultimately, the court found that this was entirely outside the only business ever conducted by that partnership, which was to manufacture and build crates. So what that tells us is that the inquiry is not on the amount of forgiveness, but rather on the type of business that was being conducted. So yes, presumably Mr. Jolly did waive, the argument is that he did waive $612,000. Certainly, that is a lot of money, but that is not the focus here. The focus is on whether or not the forgiveness of rent at all is within this business of leasing, and it's pretty clear in this case that it is.
Counsel, I have a question following up on your speculation point. Doesn't Randall Jolly testify that the reason they're signing these loan documents is so they can be repaid the unpaid rent? That doesn't sound speculative. That sounds like he has knowledge that the rent is going to be repaid. Where am I wrong in my understanding there?
So Randall Jolly's testimony specifically, Randall Jolly did not, it goes back to that same point, which is that Randall Jolly, who is not a partner in JTM, was speaking to his father about this. He was not involved in those conversations with Miss Otto and Mr. Jolly where that oral modification was made. So again, his testimony may not be speculative, but it isn't that personal firsthand testimony that we have here and that the trial court credited. And because that is a factual finding, and it is the factual finding that the trial court made, it's afforded a presumption of correctness, whereas these legal issues that are before the court here today are not. So when the trial court found Ms. Otto's testimony more credible than Mr. Nichols or Mr. Randall Jolly, that should be afforded the presumption of correctness here today. Your Honor, I see that I'm almost out of time. I will reserve my 4 minutes unless the court has any other questions.
I hear none, so you have your time for rebuttal.
Yes, thank you.
We'll hear from the appellee.
Thank you, Your Honors. May it please the court, my name is Lauren Carroll from the Hamlin County Bar, and I represent the appellee in this matter, JTM Enterprises. JTM is a Tennessee general partnership that owns property located at 425 Jones Franklin Road in Morristown, Tennessee, and for a period of time leased this property to Oddello Industries, LLC. Specifically, Oddello leased approximately 408,000 square feet from JTM and paid them $61,200 in monthly rent. Multiple leases governed the time that they had a landlord-tenant relationship, and for the latter part of their landlord-tenant relationship, Oddello was leasing 200,000 square feet of space for $25,000 monthly rent. It is undisputed that between November of 2017 until August of 2018, no rent was paid to JTM from Oddello. JTM asserts that it is owed $612,000 for these 10 months of rent. Oddello asserts that it owes nothing for these 10 months of unpaid rent, and the trial court weighed the testimony and evidence presented before it and determined that Oddello owes JTM $504,000 for these 10 months of unpaid rent. Of course, JTM, we first argued that the trial court was incorrect in setting aside the default judgment that JTM had obtained on February 13, 2020. JTM filed the complaint against Oddello, had the registered agent served, and set it for a default hearing. We aver that based on what was presented to the court that day, it properly entered a default judgment. An answer and motion to set aside was quickly filed by Oddello once it learned of the default judgment, but it had failed to enter any pleading at any point in time prior to that date, even though it fully knew about the lawsuit. In May of 2020, when we had a hearing, the court didn't address any reasoning in its order as to why it was taking the matter under advisement, but it did not directly set aside the default judgment, merely encouraged the parties to go try to put a stay on the execution, encouraged us to try to go resolve our differences. And then again, even during the April of 2022 trial and hearing, and then its subsequent order, the court did not address any reasoning as to why it did not permit the default judgment to stand, and merely stated it preferred a trial on the merits as opposed to a default being entered. The trial court did not apply any legal standard or any reason to set aside this default judgment. It didn't address any of the factors. And we believe that there was a definite injustice to JTM in having that default judgment set aside. More than just a mere passage of time, JTM lost the ability to proceed on the judgment it had obtained, loss of post-judgment interest, additional years before there would be any finality in the case, and then obviously had to pay additional attorney's fees and cost. And I do just want to note in the record, in the transcript on page 5, when the trial court is flipping through that court record, it notes that it referenced that there was a notice of hearing within that trial, or within that trial court record. I'm not sure why that's not within the technical record here, but the judge himself does reference, again, transcript page 5, that there was a notice of hearing within that file. JTM, we go on to assert that even if the trial court had legitimate, although not articulated, reasons to set aside the default judgment, after the trial, the court should have determined that JTM was entitled to a judgment for $612,000, the 10 months of the unpaid rent. As counsel stated, JTM was in the leasing business. And for the purpose of this case, it had 408,000 square feet of space that they leased. This was how they made their money. They're not in the business of giving away rental space for free. That's not what Gene Jolly's intention ever was. That's not what he presented to his partners and his son that he was doing in his negotiations with Oddello.
Counsel, does the lease contain any express prohibition in terms of how it can be modified? Is there any language in the lease that says the lease can only be modified in this way or that way?
Unfortunately, I do not believe that there is. Those leases were not the best leases. At the trial court, I at least gave a disclaimer that those were not prepared by myself. I don't believe they were prepared by any attorney. So I don't believe that there was anything within the lease that referenced how it could be modified.
Counsel, a lot of the argumentation in terms of the authority issue seems directed at what the partners would have thought, or that Mr. Jolly wouldn't do this. He wouldn't waive $600,000 without talking to his partners. I'm trying to figure out in terms of authority, though, and apparent authority in particular, how is it that Ms. Otto is supposed to know that he doesn't have authority? Let's say everything asserted is true, that he wouldn't have done it, sort of just assuming for purpose of argument, though, contrary factual circumstance, that he actually did forgive. How is she supposed to know that he doesn't have the authority to do this?
And I think what it goes to is the second part of the statute on partner agent of partnership, which states that an act of a partner which is not apparently for carrying on in the ordinary course the partnership business or business of the kind carried on by the partnership, only if at that point it was authorized by the other partners. This, again, giving away free space, 400,000 square feet of space, that's not in the ordinary course of business. And I believe Ms. Otto was unreasonable in believing and or relying on the fact that Mr. Jolly said, you can stay here in this 408,000 square foot building that typically goes for $61,000 a month. You can stay here for free, rent free for an indefinite period of time, because at that point in time, JTM did not know how long it would take Ms. Otto and Oddello, the business, to get back on its feet to be able to repay, what they believed was that she would then repay this rent. So
it's your position that as a matter of law, he could not have had the authority to do what he did? That's what the trial court found, I guess.
Correct. That is what the trial court found, and while we didn't get an exact reason from the trial,
I guess we're supposing some, but how do we, or how does the trial court know that he didn't have a business reason for doing this? He had no other tenant lined up. He hoped his tenant would get done and say, okay, I'm going to risk forfeiting this money for a while for a business reason that they're going to get back on their feet and go.
Well, and I think we do have the testimony from his son, Randall Jolly, and the testimony from one of his partners who said that Mr. Jolly repeatedly told them, They will pay, they will pay, they will pay. They just need some time. Expressed to his son and to his partners that, just give them some time. I think as the trial court found that what Mr. Jolly did and Ms. Otto did is that they reached this true understanding, whether Ms. Otto thought this or not, but reached this understanding that this repayment of rent was going to be punted down the road. I believe that's exactly what the trial court said. We're just going to kick it down the road, and give them some time to get back on their feet. Like Your Honor pointed out, help them refinance these loans. I think Mr. Randall Jolly, who was present at some of those meetings where those documents were signed, said that, we did believe that they were going to get some cash out to pay us back. So I think it's just that again, Mr. Jolly wasn't saying I'm giving up $600,000. I'm forgiving. And again, at that point in time, in late 2017, no one knew how long. Are we talking about 1 month? Are we talking about 6 months? Are we talking about 2 years? So that there wasn't this true forgiveness of rent. It was a push the rent down the road, get back on your feet, refinance these loans.
But then you have the challenge of the loan documents that Ms. Otto filled out, basically, and Mr. Jolly confirming that all is well, there's nothing owed, there's nothing in default. And so is it not problematic that he takes that position for purposes of allowing Ms. Otto to get a loan, but then, and now you all are trying to say that's not really what he meant?
I understand, and yes, we do have Randall Jolly, who said that during this period of time when these documents were signed, that this was it was for the purpose of them being able to stay in business, get back on their feet, because if they're able to get back on their feet, remain in business, then we do have this tenant, and we are going to get this money.
So was he testifying that the documents that were signed were inaccurate?
No, I don't think anyone said that the documents that signed were inaccurate, and I believe
were they accurate?
In a sense, I believe yes.
What sense?
Again, looking at the date that those were signed, which was the end of 2018, the end of May of 2018, prior to, they had signed a new lease, this third lease, and even Oddello's attorney at trial in his closing argument stated, page 53 of the transcript stated that the third lease is, after these were signed, the third lease is in place and stated no default. And under that third lease, there wasn't a default. I also think
everyone agrees that the purpose of this loan was to refinance, obtain money, and that if in fact it had been disclosed that Mr. Jolly had an expectation that Ms. Otto would repay some $600,000, that there was an existing debt of $600,000. If that had been disclosed, this loan that Ms. Otto tried to get would not have gone through. It appears borderline fraudulent.
We understand, and I believe the trial court helped, again, find another way that I think he said that the parties could honestly sign these documents, because in their mind that there had been this oral modification of, yes, there is this amount that's owed, but that amount is going to be repaid. And we have this understanding that that amount is going to be repaid. And so we, JTM, are not deeming you, Oddello, in default, and will help you, assist you in getting these loans refinanced.
I'm struggling to see how Mr. Jolly has the authority to kick down the road $600,000 and month after month after month allow this tenant to stay on, but doesn't have the authority to waive it totally. And how it is that Ms. Otto is supposed to know he has the authority as to one and not as to the other.
And I believe that, again, it's in the business of collecting rent, and he was going to, the business was going to still collect that rent. It was just he was waiving the ability to collect that rent each month when it was due. It was still accumulating. He wasn't forgiving the rent. The rent was continuing to accumulate. and was going to be repaid. And this is what we know from the testimony, that he was going to his partners and telling his partners. One of the partners who testified said that they had multiple meetings about this situation with Oddello. There were multiple questions from the other partners as to what are we doing about this rent? Why have we not evicted them yet? And so he had the authority to, enter into a form of a modification, but would not have had the authority to completely forgive the rent. And I think it's unclear, Ms. Otto in her testimony, yes, at some point she refers to these conversations that she had with Mr. Jolly as informal conversations. In response to her attorney, she answered, was there any discussion about rent? No. But didn't say, but then also states, well, yes, 4 years ago, I remember him using the exact word forgiven. I think it's, again, her interpretation of what these informal conversations were was just completely misplaced and was unreasonable. It was unreasonable for a business person to believe, who's in a relationship with another business, to believe that I'm going to be able to sit here and operate my business out of this 400,000 square foot building for free indefinitely. So we believe that yes, $612,000 of rent is owed, and it is owed to JTM. I think in regards to, just touching briefly on the equitable estoppel argument, would it not be just as inequitable to tell JTM, again, a business that's in the leasing business, that they don't get any rent, any payment of rent for these 10 months that this business was sitting in their building, and we just believe that JTM expected to be paid. Oddello made a representation that they would get back on their feet and would be paid. Yes, Mr. Jolly was good to Oddello and gave them time, maybe gave them more time than what he should have given them, but gave them time, and we believed, and the court found that they were entitled to some rent. Now,
Counsel, did the trial court judge rule on the equitable estoppel argument in this case?
No, it is my understanding with what the trial court did, there wasn't really a true understanding of what the reasoning was, which is why, of course, we dispute that there should have been any kind of credit given. The Oddello was in the 408,000 square foot space and was accruing, as the trial court did say, as long as possession was maintained, rent was owed. So while they were in the larger space, may I finish? My time is expired, if I can finish that. While they were in the larger space, they were responsible for the $61,200. Once they moved in September 2018 to that smaller space, then at that point is when their rent would have been reduced to the $25,000.
One more question.
Yes.
Do you agree that the basis for the trial court's decision was that Mr. Jolly did not have the authority to waive the entire amount of rent that was owed?
Correct.
I mean, that's where it comes down to, is the trial court found he had no authority to do this.
Correct.
Okay. We'll hear from the appellant rebuttal.
Your Honors, I'd like to briefly address the equitable estoppel argument that JTM raised in its oral argument and that Oddello raised in its brief. In some respects, the equitable estoppel argument is even more straightforward than the legal authority argument, because it doesn't turn on that legal authority of JTM's ability or authority to waive Oddello's rent. This issue turns on the undisputed facts in the record, showing that deep, albeit misplaced, reliance of Ms. Otto on Mr. Jolly. So it's undisputed that Oddello had the right to terminate its lease early if it lost its client, Temper Seeley. In 2017, Oddello did lose that client. Ms. Otto sought to terminate the lease, and Mr. Jolly told her to stay. The only evidence, as I've mentioned, in the record of that conversation comes from Ms. Otto. He told her that he would forgive her rent payments. Ms. Otto, relying on Mr. Jolly's promise to forgive rent until she could get back on her feet, agreed to forbear in terminating the lease. Ms. Otto then did not pay rent from November 2017 to August 2018. And the record doesn't reflect that any late rent notice or letters or any other communication was sent from JTM to Oddello about rent missing for a 10-month period. So, Your Honors, this is a classic case of equity and fair dealing. JTM made certain promises and then filed this lawsuit in an attempt to renege on those promises. So, simply put, this is unfair, and the law recognizes that conduct of this nature cannot be permitted. Estoppel depends on looking at the totality of the situation and the circumstances. Courts consider 6 factors, 3 against the party against whom estoppel is asserted, and 3 of the party invoking that estoppel. For JTM...
But the trial court made no finding that this promise was or wasn't made.
Your Honor, that's the issue was raised before the trial court. Counsel for Oddello raised the issue, but the trial court's opinion did turn on the legal authority issue.
So the trial court never found one way or another whether or not, yes, the parties had agreed on this. They simply found that he had no authority to do it.
The trial court found that the parties had orally modified the lease, but that oral modification, the only evidence of which is that it was a complete rent waiver, that Mr. Jolly did not have the legal authority to actually effectuate that factual finding. Yes.
Counsel, you say the only evidence, but again, didn't Randall Jolly testify that his father told him that that the reason they're signing these loan payments is because there's essentially a delay in payment? I mean, it sounds like it's not the only evidence in the record, and maybe you feel that there's stronger evidence in the record to support your position, but we don't have a factual finding here from the trial court, do we?
We do have the factual finding, Your Honor.
Of modification, but not of what the modification was, right?
That's right. Well, Your Honor, no, I would disagree, and that would not be Oddello's position today. The trial court credited Ms. Otto's testimony in finding that there was an oral modification. So there was a factual finding on that issue.
Well, I guess he credited it in part. I mean, he agreed that there was an oral modification, just not the terms of which he disagreed with what Ms. Otto said they were. He said it's not a waiver, it's just a pushback, basically, a delay.
That's what Randall Jolly said.
And that's what the trial court found, right?
The trial court found that Ms. Otto and Mr. Jolly had agreed on an oral modification, but that Jean Jolly didn't have the authority to effectuate what Ms. Otto said. So the finding was then that I credit Ms. Otto's testimony that Jean Jolly and her orally modified the lease based on the personal knowledge that she brought to the hearing that day, but then it became a legal issue thereafter, saying even if that is true, even if Jean Jolly said that, he didn't have the legal authority to effectuate that.
Your time's expired, counsel.
Oh, sorry, Your Honor. It shows.
Court's thanks to counsel for both sides. We appreciate your arguments today and your briefs in this matter. We're going to take a very short recess right now to kind of swap out some judges, but you all are excused, and we'll call the next case just as soon as we get back in. It will be a very short recess.
All rise. This court is in a short recess.